Welcome back to the Constitutional Clarion. A number of viewers have asked me to finish my series on immunity in Australia with a comment about judicial immunity. As the High Court recently handed down a judgment on this subject, I'll give a short explanation of it. The case is Vasta and Mr Stradford, a pseudonym, from 2025. In proceedings in the Federal Circuit Court in 2018, Judge Vasta decided that one of the parties in a family law property dispute, who was given the pseudonym of Mr Stradford, was in contempt of court and sentenced him to a term of imprisonment of 12 months, with the first 6 months to be served in custody and the rest to be suspended for a period of 2 years. Mr Stradford was detained upon the 6th of December 2018, but was released by order of Judge Vasta on the 12th of December 2018 after a legal representative for Mr Stradford argued that the judge had been in error in relation to his finding. Mr Stradford then appealed against Judge Vasta's decision and he succeeded, with the contempt finding being set aside. The court held that the judge's orders were made as a result of jurisdictional errors and that the process employed by Judge Vasta was devoid of procedural fairness. It would be an affront to justice, the court concluded, to permit the contempt declaration and the imprisonment order to stand. Mr Stradford then sued Judge Vasta, as well as suing the Commonwealth and Queensland, whose officers were involved in detaining him, for false imprisonment. There were arguments about the legal validity of the imprisonment order and the obligation of police and correctional officers to give effect to warrants and orders for imprisonment. But I'm not going to deal with those issues here. I'm just going to focus upon the issue of immunity. At first instance, Justice Wigney in the Federal Court held that because Judge Vasta was a judge of an inferior court, and due to the nature of the errors that he committed, his actions were not protected by judicial immunity. There had long been a distinction, albeit an unclear one, that had been drawn between the immunity of judges in inferior and superior courts. Well, what are they? Okay, superior courts include the High Court, the Federal Court, and the Supreme Courts of the various states and territories, whereas inferior courts include local and district courts, and in this case, the Federal Circuit Court, as it was then known. The controversy over the immunity issue led to the matter then being removed to the High Court for final determination. The High Court upheld the common law judicial immunity from civil action for judges of inferior courts. All of the judges upheld it, although in this case Justice Edelman treated it in a different way, as a defence of justification rather than an immunity. But for present purposes, I'm just going to call it an immunity. The immunity was upheld as applying to all courts, whether they be inferior or superior, because the same rationale applies regardless of the status of the court. Two main reasons were given for the common law immunity of judges from civil liability in relation to their exercise of judicial functions. The first is to secure fairness to litigants by ensuring the protection of judicial independence. The second is to ensure the finality of the determination of legal disputes. The explanation for the judicial independence rationale is as follows. Litigation is adversarial. In each case, there's usually a winner and a loser. Now, the loser will ordinarily feel unhappy and often hard done by. The loser, if financially well-resourced, may well seek revenge and to relitigate the issue by suing the judge. If judges were personally liable in relation to such suits, then there's a risk, or at least the perception of a risk, that they will favour the well-resourced litigants who are likely to sue them, so as to avoid such a suit. In order to make the judicial system fairer to everyone, It's designed in such a way as to make the judge independent from financial pressure. For example, a judge's salary cannot be reduced because the government doesn't like the way the judge decides cases. Nor does the judge have to worry that a disgruntled millionaire litigant before him or her will sue the judge personally if the judge decides against the millionaire. The judge should be able to decide the matters in accordance with the law, free from pressure and influence. Chief Justice Gageler and Justices Gleeson, Jago and Beech-Jones explained in their joint judgment that judicial immunity provides institutional protection for the judge to perform their judicial duty free from pressure. Importantly, they said it also enhances public confidence in the impartiality of judicial decision-making by foreclosing even the assertion that the prospect of a suit against the judge may have had some conscious or even unconscious effect on the decision-making process or its outcome. Justice Gordon described the immunity as securing judicial independence so that judges are freely able to exercise independent judgment. It protects against a risk of bias arising from threats of litigation. The other rationale is the need to achieve finality in determining legal disputes. The legal process of decision-making by courts and appeals then to higher courts is long and tortuous enough as it is. There comes a point when finality needs to be achieved so that the matter's not dragged on any further, taking into account the cost, the time, and the stress involved for the various parties. The joint judgment said that the finality of judicial decisions would be undermined if those disappointed with the decision could bring proceedings against a judge as a means of attacking the judge's decision. Judges are required to give reasons for judgment when they decide a case. Requiring them then to come to court in a separate suit against the judge and to give evidence about how and why they decided the earlier case would undermine the finality of their judgments. Now, all of that does not mean, however, that immunity is without limit. The joint judgment said that there were limits to the immunity that related to the exercise of judicial functions. Their Honours said, self-evidently, the immunity does not extend to the judge's private acts unrelated to their judicial office, nor could it extend to them attempting to perform the judicial function of a court to which they're not appointed. So, for example, a probate judge purporting to run a criminal trial. However, a judge does have immunity in relation to the exercise or purported exercise of their judicial function or capacity as a judge of the court to which the judge has been appointed. This immunity applies even if the judge is mistaken as to the extent of his or her jurisdiction, given the ambiguities and uncertainties that do exist about the limits of jurisdiction. The joint judgment also stressed that it was only addressing immunity from civil action here, not any judicial immunity from criminal responsibility at common law. Justice Gordon observed that criminal offences apply to judges for egregious conduct such as taking bribes. She also noted that the immunity does not extend to roles performed by judges acting persona designata, which means that they're appointed to exercise functions in a personal capacity, not as a judge of the court. Justice Edelman added that there was no immunity from wrongdoing where a judge acts entirely without authority, such as descending from the bench and punching counsel in the face during a hearing. The joint judgment concluded that the rationales that they'd given for the immunity were relevant regardless of whether the court was an inferior or a superior court, or indeed whether it was a federal, state or territory court. Their Honours pointed out that the Commonwealth Constitution refers to federal and state courts all of which must satisfy minimum requirements of independence and impartiality. They didn't think that this constitutional guarantee of judicial impartiality should be undermined by a limited immunity doctrine of uncertain scope and operation which didn't conform to those rationales. Now, where does this leave litigants who have been the subject of bad judicial decisions or egregious treatment by judges? The joint judgment pointed out that courts in Australia are subject to an appellate structure or judicial review, so wrong decisions can and should be corrected through this process. Their Honours considered that judicial accountability comes through the system of appeals and review. These judgments, of course, are all very public, so that there is a form of public accountability and correction when judges do get things wrong. If it happens too often, it does tend to attract media attention and criticism too, which can indeed turn to public humiliation. But what about disciplinary action? Now, this can be difficult with respect to judges because their independence needs to be protected to ensure the fairness of the system. You may have seen recent calls in the United States for the dismissal of all judges who decide matters against the wishes of the current federal government. In Australia, the constitutional protection of the tenure of judges is intended to stop such bullying action. Under Section 72 of the Commonwealth Constitution, federal judges can only be removed by the Governor-General in Council after a resolution has been passed by both Houses of Parliament seeking the removal of the judge on the ground of proved misbehaviour or incapacity. The point of this is first that it's not controlled by the government alone. Each House of Parliament must approve the removal. Second, it can only be for proved misbehaviour or incapacity, not because the government doesn't like the judge's judgments. But this shouldn't mean that there's no disciplinary system for judges who behave badly. Most jurisdictions have a system under which complaints can be made against judges, investigated and dealt with. At the federal level, the system's not the best and it has been slated for reform for some time, but that hasn't occurred. Nonetheless, there are mechanisms available to complain to the Chief Judge or Chief Justice of the relevant federal court and for the establishment of a conduct committee to investigate the complaint and report findings. If the committee recommends parliamentary consideration of removal on the grounds of proved misbehaviour or incapacity, the Chief Justice or Chief Judge of the relevant court may refer the matter to the Attorney-General for Parliament's consideration. In practice, in relation to less serious matters, a judge is more likely to be counselled and perhaps supported to be able to do better, whereas in relation to the more serious matters, the judge may well be persuaded to resign on the basis that that's preferable to facing parliamentary removal. Thank you for watching the Constitutional Clarion. Next time, I hope to do one on the recently passed political donations laws, which are quite interesting. And I look forward to seeing you then. Goodbye.